Thank you, Mr. Chairman. I'm Jay Harvey. I'm here individually and on behalf of Texas Trial Lawyers Association, testifying in favor of the bill. First thing I want to do is address the issues that came up in the Wilson case, or we sometimes refer to as Presbyterian. The patient reported to the hospital the night before for a planned induction for delivery, and sometime the next day, hours later, after an uneventful labor, the delivery proceeded as normal until at the end the shoulder became lodged. It's called shoulder dystocia. The doctor performed various maneuvers to try to free the shoulder, resulting in the delivery with the child having a very severe injury, usually called Erb's palsy. And the family brought a lawsuit based upon the fact that the doctor failed to use the correct maneuvers in freeing the shoulder. That was what the base of the lawsuit about. This was her ongoing obstetrician that she had been seeing there in the hospital. She'd been in since the night before. So the court was asked to address, in order to get willful and wanton, does the patient have to go to the ER and then to the OB? And as Senator Duncan said, the predominance of this opinion addresses where was the comma? Where was the comma? This bill doesn't address that. When we first talked to Speaker Moody, it was never our intent nor anybody else's intent to try to change that concept that the willful and wanton standard can go when the patient reports directly to the OB without having to go through the OR. And that was the issue, the sole issue before the court. However, and in the pamphlet that I have laid out for you, there are two tabs on the opinion, which is behind number 5. One of them shows the conclusion, and you can read from the conclusion that the court not only concluded that you don't have to go through the ER, but you can go directly to the OB, which I understand that, but the court went well beyond that said any emergency that subsequently arises in the OB unit gets willful and wanton standard. So you've heard from Senator Duncan and you've heard from Representative Island that is specifically the opposite of what was intended when this bill passed in 2003. It was never the intent. Now, here's how we can know that's the case. When you look behind tab 2 on the pamphlet, it defines emergency medical care, and it has two exceptions, two things that are not emergency medical care. That includes care that occurs after the patient has been stabilized, and if the care that is in question is unrelated to the original emergency. To address the physician's complaint was, how do you determine stabilization? That's what juries do. They determine that based upon on the evidence. So this is already in the statute about you don't get willful and wanton after the patient is stabilized. You don't get it if the emergency occurs and it's unrelated. What the bill does, it adds basically two more sections. One, if the patient comes to the emergency room or to the OB not in an emergency, not needing emergency medical care but needing medical care, you wouldn't get willful and wanton. Or if the physician or the nurse, the healthcare provider, caused it. So under tab 3, it outlines where the standard is, but tab 4, it provides for what jury instructions are. And I know this is kind of down in the weeds, but I hope you'll indulge me. But when you look at what 74-154 says is, if certain things occur, Section A, which is the jury instructions, don't apply. Those are things like if the care occurs after stabilization, if it's unrelated, or if it's caused by the defendant. What sense does it make that those would affect whether or not jury instructions are given? Those should, in fact, direct whether or not it's a willful and wanton standard. So what Speaker Moody's bill does, it takes those things from the jury instructions section, 154, and moves them to 153, to the substantive section, and adds that if the patient comes in not in an emergency. This is not to change the standard of care. This is not, I don't care what anybody says, this does not do away with willful and wanton. This does not. willful and wanton applies in the face of an emergency, and it continues to apply in the face of an emergency. But when there is stabilization, or when there is a non-emergency, when emergency medical care doesn't apply, it's not willful and wanton. This bill achieves just exactly what Senator Duncan, Representative Island said was the intent in 2003.
Thank you, Mr. Harvey, for your testimony. Members' questions, Chairman Meyer.
Sure. So we heard the physician's concern about stable and how you define it. I mean, I appreciate you're an attorney like I am. I don't know and couldn't even get close to defining it. So how are you saying that you can absolutely get stable when I've got a couple of physicians telling me who this is what they do for a living, that it would be really, really hard to define that term?
It is hard to define that term.
Okay.
I don't dispute that.
Okay.
However, the way it works is, and it's been in existence since 2003, there's been a key fact of this area of the law since 2003. From the early on in the pattern jury charge, we have an issue on stabilization. And so it's determined by, I will bring my expert witnesses in to say the patient is stabilized, and here's the criteria, and they say why. Maybe the defense brings in expert witnesses, say the patient wasn't stabilized, and this is why. And so we call it, that is a jury question to be determined. It's not something that just the lawyer or the judge, but the jury decides that based upon the evidence, not just that somebody makes a conclusory statement.
Right, but I think they were saying as well in an emergency situation, it's a little harder to define what is stable. Do you disagree with that premise?
I don't, and that's why,
Okay.
and the very definition judges their conduct under the same or similar circumstances. To try to say this is all Monday morning quarterback, it's not. This is the very definition of negligence is under the same or similar circumstances. And so when I present, if I do, an ER physician to testify, that ER physician understands split decision making is split second decision making. And so that's a different concept. It is under the circumstances. So this is not to do away with that. This isn't to cut back on the number of ERs. This is to say, if you're not in an emergency situation, don't get this extended protection.
I know, but I think we do need to listen to the physicians and understand that the job that they're doing is quite different than what the rest of us do, and therefore we need to make sure there are protections. Let me finish. Protections in this bill to make sure they are, in fact, protected in these unique circumstances. And I'm not saying you're testifying differently. I just wanted to make sure that was clear.
And that's why I think the definition that was adopted in 2003 provides that, is if the care is provided. I mean, this is an existing law. If the care is provided after stabilization, it's not willful and wanton. So that is the threshold question that has to be decided in any of these cases firsthand.
Understood. Thank you.
Members, any other questions?